we have a special order upon the adjournment of our session, Senate Bill 1195, regarding professions and vocations. And Senator Hill, if you'd like to proceed. This is item number 1, members.
Well, thank you, Mr. Chair.
Or item number 0.
Yes, I think it's item number 0. But SB 1195 has 2 major parts to it. First, it deals with a very important issue regarding board actions, primarily regulations of the boards, which must be reviewed by the Director of the Department of Consumer Affairs to assure they have not have any unreasonable anti-competitive impact on the marketplace. And the second part of the measure deals with extending the operation of the Veterinary Medical Board for 4 years and making modest changes to the board's operations. In terms of providing additional authority to the Director of the Department to review board actions and regulations, this is in response to a recent U.S. Supreme Court decision and guidance from the Federal Trade Commission on what states must do to provide adequate oversight and supervision of board actions, which could potentially have anti-competitive impact on the market, and which do not further any clear articulated state policy. If this review does not occur, then boards left to their own devices could find themselves involved in antitrust litigation. The Federal Trade Commission indicated that to comply with the court decision, the state must provide active supervision over state boards in which a controlling number of the decision makers are within the profession they regulate. The person performing this function must not only independently review the board action, but be able to disapprove or modify the particular decision of the board to ensure they are in accord with state policy and are not exposing consumers to anti-competitive actions. The Director of the Department seems to be in the best position to provide this supervision, since much of his current responsibility involves review of regulations of boards and the ability to disapprove regulations if necessary. This measure will also provide an additional standard for the Office of Administrative Law when reviewing regulations to assure that the impact of the regulation on competition is justified. Finally, the bill clarifies when treble damages may be awarded against a member of a regulatory board for an antitrust violation, and would eliminate the requirement that an executive officer be a licensee of the board. This would eliminate any undue influence on board members regarding the profession. I have with me today Melinda McLean, who is the Deputy Director of Legislation for the Department, who can make a few brief comments regarding the attempts the Department is making to address this issue.
Thank you, members and chair, for allowing me the opportunity to speak. As the senator mentioned, this is a very important issue that we think should be addressed, dating back to the first informational hearing that this committee held back in October. You know, we've been taking a lot of proactive approaches to really make sure that, you know, the members and the boards are as well equipped to be able to mitigate against any antitrust violations. We've done that in a variety of ways. We've had a training that we collaborated with the Attorney General's office, which just kind of gave an overview of the North Carolina case and ways to help mitigate against any antitrust violations, as well as we have a board member orientation training where we've incorporated some antitrust best practices. And then we've been doing a variety of different presentations during various board hearings and meetings as they occur. And so we definitely look forward to working with the senator on this measure and providing any technical assistance that we can, and like to commend the senator for taking this up at such a time as this. Thank you.
Thank you.
Good afternoon, Madam Chair, members. Ed Howard on behalf of the Center for Public Interest Law. Also want to thank the Senator for authoring this important bill, and the Department for taking such a constructive role in making sure that the state is not subject unnecessarily to antitrust liability. There are, Madam Chair and members, already, just since last year, 6 lawsuits that we know of filed nationwide that have already placed at risk the antitrust immunity of states throughout the country. Likewise, the Manat firm, recognizing the risk to states here, has said, quote, that there is a growing trend of antitrust lawsuits challenging actions of state licensing boards. This bill does the absolute minimum required to make sure that the state is not subject to antitrust immunity, as those minimums are defined either by the U.S. Supreme Court or by the Federal Trade Commission in its guidance. The first is the U.S. Supreme Court has said that there needs to be, quote, the power to review and disapprove of actions by a non-market participant. The U.S. Supreme Court has also said that that review has to be substantive, meaning you've actually got to look at what the policy is. And third, the FTC has clarified that the non-market participant regulator has to be able to, quote, veto or modify the action. This bill satisfies those minimum criteria. Likewise, the FTC and the Supreme Court have both said that if there is a clear statute that says that a board has to do something and the board is just following that ministerial duty, there's no antitrust immunity. The legislature and the governor have together created the supervision that's required. This bill captures that. Likewise, the bill says that it's areas where a board is exercising discretion in interpreting legislative policy where the potential risk of antitrust liability comes in. This bill embraces that too. Its bill does a great job of reflecting the minimum requirements to keep the state safe, as reflected in the U.S. Supreme Court and the FTC guidance, and respectfully ask for your aye vote.
Others in support?
Thank you, Madam Chair and members. Christina DeCaro, representing the California Veterinary Medical Association. We have a support if amended position on the bill. We want to thank this committee for the very thorough overview that you did of the Veterinary Medical Board during Sunset Review. We feel very strongly that a board should continue in statute, and thank you very much. Our if amended position is really a thank you to the committee. That pertains to the issue of compounding. That's been something that we've brought up in our letters to the committee, and then our executive director testified to that at the Sunset Review Committee. We've been compounding since the beginning of the profession. This is issues like mixing two medicines into a syringe or a drip bag and giving it to the client in the animal hospital. And so we came to the committee, hat in hand, saying, how can you help us deal with this issue? There seems to be an agreement that perhaps the Veterinary Practice Act is not as tight as it should be in terms of giving us this authority to compound in the office. So your staff all met with us on Thursday, and I mean all of your staff met with us on Thursday, and the Board of Pharmacy, and it's going to be essential for them to help us out through this process. And so, again, we just want to say thank you very much. It's not a policy issue where we have any concerns. It's just the mechanics of how to write this where we have overlap between the two boards. So, again, thank you so very, very much.
Thank you.
Others in support? Those in opposition?
Madam Chair, members, Jim Gross on behalf of the California Society of Certified Public Accountants, the California Pharmacists Association, and the California Psychiatric Association. I must say, I believe this is the first time I have opposed Mr. Hill's bill, and I think, yeah, thank you for that. We haven't opposed unless amended, and we have monitored very carefully the discussions that have taken place in this committee and in the legislature generally with respect to the North Carolina decision. And we do agree that there is need for legislation to address the problems that the case creates or identifies and that have subsequently been discussed before the legislature. Where our disagreement is the role that has been chosen for the director of the Department of Consumer Affairs. While we hold both the position and the current chair in high esteem, we believe that, one, it is not necessary to provide that level of authority and discretion to the chair in order to meet the requirements of the Supreme Court decision. And in fact, we have some doubt as to whether that is the type of state supervision that the case calls for. I know that there's been a subsequent case in the state of Texas and discussion about a role given to a public official in the state of Texas, but we do not believe that does in fact follow what the Supreme Court decision laid out. Unfortunately, we believe that empowering the director with that authority, particularly given how, frankly, ill-defined that authority is in the bill, along with the problems of politicization that will create, we think is going to undermine the role of the boards, undermine the traditional role of the director, and fundamentally change the nature of the role of licensing bodies generally. We do endorse, however, the role of the Office of Administrative Law. As was outlined in the Center for Public Interest Law letter authored by Mr. Felmuth and has been repeated by Mr. Howard, we believe the OAL construct is appropriate for this role. Now, of course, as has been pointed out numerous times, they currently do not play a role in reviewing anti-competitive activity. We believe their role can be expanded. We believe they can ensure that they have the professional assistance needed. I would contrast that with the language in the bill relative to the director serving that function. As we read the language, the director can consult with professionals of his or her choosing. We think that's, again, potentially very risky with respect to how that process might unfold. And we also think it's risky because we think it is much better to have an agency that is structured to use professionals in a way that we feel follows better the Administrative Procedure Act than it is for the director to have that type of discretion in seeking that professional input. So to repeat, we agree that legislative action is needed. We thank Senator Hill for undertaking that effort. We are sure that this bill can, or the portion of this bill, can get to where we all believe is necessary to protect the interests of licensees and the state from the types of problems that will ensue if we don't address them. But currently, we must be opposed to the role that has been carved out for the director. Thank you very much.
Thank you.
Alicia Sanchez. Alicia Sanchez, representing the California Medical Association. We actually have yet to establish a position. There not being a middle area being called up, this is probably the most appropriate place. We are continuing to do an analysis, but we want to ensure that the authority that's expanded is not overly broad. I think the Attorney General's analysis that was done suggested that California has done a lot already to protect against antitrust violations, and so just wanting to ensure that we're being very focused on what is necessary as opposed to doing something that's overly expansive. And we look forward to continuing to work with the senator on this issue. Thank you.
Thank you.
Good afternoon. I'm Brianna Pittman with the California Dental Association. I want to associate myself with the comments made by my colleague with CMA. We do not have a formal opposed position. We're in a very similar situation of, starting to look at the new amendments. We do have some concerns that the language as drafted is a little bit overly broad and could potentially undermine some of the decisions that are made by the boards. Do really appreciate the interest in, making sure that boards are complying with the Supreme Court ruling, and look forward to working with the AG, DCA, and your office to do that. Thank you.
Next.
Good afternoon, Jane Schroeder with the California Nurses Association. We also haven't taken an official position on this board, but we do have some pretty serious concerns that I wanted to lay out. We have a major concern with the prohibition on the executive officer of the Board of Registered Nursing being a licensed nurse. An EO who's also an RN is really in the best position to be able to effectively prioritize and organize board affairs and maximize the public protection goals of the board, because they do understand the complex issues that come up regarding competency and safe practice and professional conduct within the nursing field. We're also really concerned that this bill will undermine the board's ability to protect the public by transferring too much decision-making authority away from the board members and to the DCA director, who's not going to have a working knowledge of the complex consumer protection issues that come up within each of the individual licensed professions. These provisions could also undermine board decisions by creating significant and costly administrative delay, and could have a chilling effect on the board's ability and willingness to pass regulations that protect the public. We also just don't think there's really any justification for such major changes. They really go far beyond what might be useful for addressing the kinds of policy concerns that came up in NC Dental. We think that the portion of this bill that addresses the treble damages issue would really be enough to address those concerns, and we are supportive of those changes. It's just really important that we don't overreact to NC Dental and end up making changes that undermine the board's ability to take actions that protect the health and safety of the public. So we are optimistic that these concerns can be addressed, and we look forward to working on ways to come to some sort of resolution. Thank you.
Thank you. Others in opposition?
Good afternoon, Madam Chair, Senator Hill, everyone else on the committee. My name is Donna Gerber, and I am a public member of the Board of Registered Nursing. In addition, I did a stint as a public member on the medical board way back in 2000 when I was on the Board of Supervisors in Contra Costa County. I appreciate the moment to speak with you. I'm here on behalf of the Board of Registered Nursing members. Senator Hill, I understood earlier today that it's your birthday, so I'm in the awkward position of saying happy birthday and sorry, but we oppose your bill. But let me explain why. The Board of Registered Nursing only learned about the April 6th amendments of SB 1195 affecting the BRN, and our board meeting of April 14th, last Thursday, and therefore we have had limited opportunity to do a more surgical response regarding the board's position on the bill. So in the interest of giving the committee and the author feedback in a timely manner, for this hearing, we received and discussed the bill and received public comment. After realizing the timeline didn't allow for a more refined response, we ended up taking a position to oppose the bill, the part of the bill that refers to the BRN, of course. Our board is opposed to the bill's deletion of the current requirement that the executive officer is an RN because it is not necessary to do so, and there are many, many advantages to the RN executive officer that would be lost. Our board is also opposed to the wholesale transfer of authority from the board to the DCA director, not because we don't get along, not because we don't work well, our staffs work well, all of that, but because it is not what the California Attorney General's office recommended. We believe it's unnecessary, and that relatively minor changes in the DCA authority to veto or modify identified market-sensitive decisions can be accomplished. We understand that SB 1195 purports to define California's response to the North Carolina Dental Board Court decision. Happily, there are vast differences between North Carolina and California. We agree with the California Attorney General's opinion that California's boards already have significant oversight by state supervision, and that there are reasonable modifications in how the state supervision by the DCA occurs in order to provide state action immunity to board members who are licensees. We also agree with the AG's recommendation to amend state law to specify that treble damages are included so that board members who are licensees are protected. Although we have not had the opportunity to offer language amendments to the author or staff, our legislative committee meets next month, and we would be pleased to offer amendments consistent with the Attorney General's opinion and work with the author on SB 1195. I would just like to add briefly that in reviewing the California Attorney General's opinion, which was requested by Senator Hill and I believe the committee, it seems very clear that, as the Attorney General says, California is in a relatively advantageous position to create these kinds of mechanisms for active supervision of licensing boards. It is worth exploring whether existing resources and minimal adjustments to procedures and outlooks might be converted to lines of active supervision, at least for the board's most market-sensitive actions. Moreover, the Business and Professions Code already demonstrates an intention that the Department of Consumer Affairs will protect consumer interests as a means of promoting the fair and efficient functioning of the free enterprise market economy by educating consumers, suppressing deceptive and fraudulent practices, fostering competition, and representing consumer interests at all levels of government. The free market and consumer-oriented principles underlying North Carolina Dental are nothing new to California, and no bureaucratic paradigms need to be radically shifted as a result. So we would ask your committee to consider these factors in your decision today. As I said earlier, our board looks forward to working with the author, if we can, to come to a conclusion that we mutually agree upon. Happy to answer any questions.
Any questions of the committee? Senator Wieckowski?
For the opposition, for the nurses, it seems as though that the veto power, the modification under the language, is for DCA to determine whether it unreasonably restrains trade. So they're not saying they have a wholesale veto power modification over everything else that the nursing board does, but on this issue, I mean, we have to do something with North Carolina Dental Board. They put the whole United States in a pickle with their arrogance over teeth cleaning or teeth whitening. All right, I'm beyond that, but this seems to be narrowly tailored just for the restraints on trade. And why would the nurses board or the executive director have any idea what is a restraint on trade given their expertise in nursing?
Well, I think what we would say is this. There are many, many good reasons, important reasons for consumer safety to have the executive officer of the Board of Registered Nursing be, in fact, a registered nurse. The question really before you, I think, is how do you try to get to addressing North Carolina without throwing the baby out with the bathwater? It's not necessary, according to the State Attorney General, it's not necessary to remove the licensure of the executive officer in order to give appropriate state supervision. State supervision can be attained through the OAL, through the routine monitoring of the BRN by the legislature, through the current authority that the DCA has over the Board of Registered Nursing. And I would just point out that, again, it's important to remember what led to the North Carolina position and compare that to what occurs in California. We have never issued a cease and desist order to affect the activities of another occupation in California. And from where I sit as a public member on the BRN, I can't even imagine a scenario where a California board could do that, given our current oversight and supervision.
Right. Well, whether they, I mean, we know the nursing board is the only board that has this, requires the executive director to be licensee, and all the other boards, they suspend their license. That was not really my question. It was on, we're focusing on anti-trade, anti-competitive aspects, and most of our boards have no idea what we're talking about, right? Whether they're qualified to be nurses or real estate agents or whatever, they have no idea, and at least we're giving the, and so we have to respond to this anti-competitive element, and it's, you know, it seems to me that the veto power over some decision, and maybe some cease and desist action that somebody will take in the future, is very limited. Because I get the second part of your objection. I know that you guys want to protect the executive director, but just on the giving the power to DCA seems to be narrowly tailored. It seems to be narrowly tailored, and then the other part of it is when the other objectors with the Office of Administrative Law, the bill further allows them, the office to, study the regulations that may be passed. So you take an action, some regulations are promulgated, and then we're going to have the administrative law or the Office of Administrative Law to look at those regulations to sort of catch again whether the DCA director missed the anti-competitive elements. So it seems that we got both sides of actions so that we can protect the immunity of all the people that we want to serve on the boards is why we're doing this.
We do not disagree that there is undoubtedly a mechanism to be able to achieve what you're talking about. I think our problem is the devil is in the details. And again, we only saw these amendments, on April 14th. And I think we would like to work with the author really around the specific language that would define more carefully, these elements. We believe that something can be achieved, no question.
I'm just looking at the plain reading of what it says, and it's asking the Office of Administrative Law to determine, among other things, whether the anti-competitive effects of the proposed regulations clearly outweigh the public policy merits. I get that you folks and all the other boards are going to do a good job on the public policy merits, because that's why you serve on those boards, right? But the anti-competitiveness, I don't see that anybody in any of these boards has any clue of what may be a well-meaning best practices in the nursing realm could be anti-competitive. This is the concern that I have from the...
And we're not opposed to additional training. We're not opposed to the OAL's oversight, which we believe already exists, to be able to get there. I think the question is the level of authoritative transfer to the director of the DCA. I note, for example, that the AG's opinion says, the Business and Professions Code also gives broad powers to the Director of Consumer Affairs to protect the interests of consumers at every level. And it goes on to clarify what those are. So I think it's just a question of having the opportunity to get in on the details of this and make sure that we are all clear as to what the definitions are.
Yeah. Senator Jackson.
Yeah, I was a little lost trying to go through this bill because the analysis doesn't make any reference to the opposition. And so listening to the opposition and then trying to put this in context, I have to say this sounds to me like we're taking a shotgun to a flea. And I'm really I don't know if that's the right analogy, but you know what I mean. I understand the court's decision about restraint of trade. I understand to the extent that we are in a parallel universe, or at least in a similar universe, that we will have to take some steps. But I'm not sure giving the Department of Consumer Affairs the authority and then we're taking away the responsibility of the executive directorship of the nursing profession, where we really do, the goal isn't to see that we don't violate restraint of trade. The goal is to make sure that we have people qualified to be nurses and that they conduct themselves appropriately in that occupation. So, again, I sort of felt a little blindsided by this and was listening carefully to the opposition and their concerns, and I think that actually they're valid, and I wish they'd come a little sooner. So I will say, Senator Hill, I can't support the bill as it exists at this time. I think it's way overbroad. I think it sort of misses the mark, even though I think it's a valiant effort. But I just, I think it really needs to be honed down. And I'm sorry, that, to your credit, you've been working on this, and the opposition, I guess the amendments were late, and everything this year, it just feels like it's all kind of, getting thrown on a wall and seeing what sticks. But I think there are just way too many issues, and would appreciate and know as an author that you will continue working with the opposition on this. That didn't come in till late because the amendments were late and because everything's late this year. But this, I think this is just not the answer. So. I'm happy to hear your comments,
Well, I mean,
I want to say that I don't. This isn't being critical. This isn't criticism. I just think there has to be a sort of stepping back and trying to come to the solution, which I think is a valuable one. But this one, it just doesn't feel right to me on that score.
There are a couple of issues that, and I guess where I'm concerned is the shotgun approach, which I don't think this is. I mean, I think this is tailored specifically to one issue, and that's the anti-competitiveness of a potential decision of a board.
But the way you're addressing it, to me, it feels like you're not addressing it in that
I think we
narrow
are
way.
addressing it because you're taking the current authority of the director, who has the ability today to look at every decision that the board makes and take some action on that, can veto those decisions. And this now just specifically says also related to an anti-competitiveness view of those decisions that are coming. And that is all that it's doing. And then with the review of the of the Office of Administrative Law. And that is strictly, and in terms of the director, Mr. Howard can reiterate that, but the issue for me is the director, the comments that you need a first person from the profession to oversee the professional board. Well, the head of the medical board doesn't have to be a doctor. I mean, the director of the medical board, I'm sorry, the executive director does not have to be a physician, podiatrist, dentist, optometrist, none of them. And they're all providing health care and oversight over health care professionals. And this is the only board that has a director that is and required to be a member of that profession. So that's another thing. So, Mr. Howard, maybe you can explain in a little more detail.
Yeah, so there are a couple of things.
The limitations of the bill.
Yes, Senator. And Senator Jackson, thanks for your comments. Of course, the North Carolina decision, neither the North Carolina decision nor the FTC guidance, which importantly, the FTC guidance came out after the Attorney General provided his decision, or his opinion. Neither of those, of course, mention a preference for the Department of Consumer Affairs of California over the Office of Administrative Law. From an antitrust immunity perspective, we are agnostic as to where the non-market participant supervision comes from. But there are several things that are absolutely bottom line that we know of. The first is that there has to be a review of decisions that have an anti-competitive potential. And those decisions are both regulatory and certain kinds of enforcement decisions. We know that there has to be a review by somebody who's not a market participant, not a licensee. Could be anybody, but we know that there has to be that. We know that that review has to be substantive. It can't just be, did you check a bunch of procedural boxes, because the Supreme Court uses that word. And we know, finally, that non-market participant has to have the power not just to reject the action, but to modify it, to veto and modify it. There is currently nowhere within the executive branch where anybody who's not market participants has that power. The Attorney General who spoke didn't seem to know that the Office of Administrative Law was not empowered to modify regulations, for example, veto and modify. The OAL does not have that power now. The director has the power to veto regulations, not enforcement type actions like this, the en masse cease and desist letters or things like that, but regulations, but can be currently overturned by a unanimous vote of the board. And I believe even the Attorney General in the hearing that this committee had mentioned that had to be amended away. So the question, both Ms. Gerber, who's a pleasure to see again, and Senator, you're right about, and Senator Wachowski, they're right about the devil being in the details. But there are some details where there's no devilishness at all, and that is the current structure right now does not provide sufficient immunity, and that the hallmarks of what it has to be are review of substance on anti-competitive conduct, the power to veto and modify. The places where the bill goes into more specifics are in an effort for it, respectfully, not to be scattershot, but provide sort of a guiding checklist as to how this functions. So, for example, there's a provision in the bill that says that when the director first looks at the action, they find that it is not authorized by state law, well, it's illegal anyway, you go ahead and get rid of it. Likewise, there's another provision in the bill that says that if the director finds that it is essentially mandated by law, well, as I mentioned earlier, the review ends, the action's upheld because the state supervision was supplied by you, Senator, this body, the Assembly, and the governor. So There are some details that we would certainly, I think everyone would welcome additional details, but the scaffolding and the structure has to, I think, well, I don't think, I think I know, has to have those basic elements. But how precisely that's done, is it OAL, is it DCA, where's the best place to put it? From an antitrust perspective, that's not an issue. That's just purely a question of where is it best to do that.
And I think given the fact, if I may,
Yes,
that we had entities that are going to be affected by this come up with I thought, not unreasonable questions and suggestions. It seems to me that, again, it's just, I think the time constraints here, I just don't, I know you're trying to address those issues, and I don't think we disagree that needs to be done. It's just the approach here just doesn't, to me, sync with what the concerns are. And again, I think with more time and again, I suspect you didn't, a lot of this testimony, which we didn't have the benefit of seeing the opposition in order to sort of get a better sense ourselves, not with anyone's fault, I would like to reiterate. I just think the timing this year has just been unusually expedited. I don't feel as though we're kind of hitting the right mark.
And Madam Chair, thank you. There was no opposition initially after the Attorney General, and that came in last week after everything was concluded. But if you look at which the Attorney General did not have the privilege of looking at when their initial letter, the guidelines that the FTC established, and one of them that clearly does not constitute active supervision of a state regulatory board is exactly the way we do business today, where an independent state agency is staff-funded and empowered by law to evaluate and then to veto or modify particular recommendations of the board, which would be the DCA today. However, in practice, such recommendations are subject to only cursory review by the independent state agency, and that they look at that, which is not specifically calling out the need to review based on anti-competitiveness. And what we evaluated over the last 6 months, or since the decision, is what is the best way to structure this in California. I think Connecticut just passed almost the exact thing that we just did, or we're proposing today. But that doesn't mean that this is exactly perfect, but that's why if it moves today, we'll have the time to work on it over the next few months to get it correct, because we have to get it right. I mean, we have to get something in the books and something passed to make this succeed, and to especially the indemnification that we're talking about. But I think the point that I wanted to make is that in some of the alternatives, we're creating new departments to try and establish these larger bureaucracies to do it. Here we're just adding one task to that position to review that particular aspect of the anti-competitiveness of a particular action of a board to protect everyone involved. So it's not as big as I think it may appear of a change.
Thank you. Senator Jackson, did you want to respond? Your microphone's on.
Sorry. No, I wanted to thank you.
No, thanks.
But I just, again, if that's the case, then why are we changing we're going to the nursing profession now and saying, and while we're at it, we're just going to require that or limit the direction of the nursing agency so that the executive director doesn't have to be have a nurse's education or training, whatever the language is. And if we're going to go there, then the question is, well, why are we doing that? I don't see that.
The concern that I saw that was raised was the fact that by having the director as a member of the profession, that position could influence the decision-making of the board because of the professional nature, rather than having an independent executive director who would be outside of that.
And yet, I don't know that we've heard any problems associated with that board having under its current constitution. So, again, we're opening up
part of our
boxes.
Conversations last year. We were on the committee last year, Senator.
I was.
I think.
I
Okay.
was.
And we had the Sunset Review was very vocal along those lines.
Thank you.
Any additional questions? There are none. And Senator Hill, would you like to close?
Well, I think we've covered the issues that are involved, and the real, to me, what is an approach that is more focused than broad. And in doing this, we're trying to create the indemnity that's necessary and to abide by the guidance of the FTC and to meet the standards of the court case. So I respectfully ask for an aye vote, members.
Is there a motion? So moved. Have a motion. Call the roll.
Motion is due pass to Senate Appropriations. Hill.
Aye.
Hill, aye. Bates.
Not voting.
Berryhill. Block. Aye. Block, aye. Galgiani. Hernandez. Jackson. Mendoza. Wachowski.
Aye.
Wachowski, aye.
There are 3 votes. We'll, leave the roll open and call the absent
Very
members.
good. Thank you very much.
Thank you. Thank you.